Obviously, the inherent power can be exercised only for either of the three purposes specifically mentioned in this section. This inherent power cannot naturally be invoked in respect of any matter covered by the specific provisions of the code, meaning thereby the section 482 CRPC would not be applicable in those cases where there is alternative remedy available provided under the code itself. Further, it cannot also be invoked if its exercise would be inconsistent with any of the specific provisions of the code. It is only if the matter in question is not covered by any specific provision of the code that section 482 can come into operation, subject further to the requirement that the exercise of such power must serve either of the three purposes mentioned in this said section. It has been held that section 482 CRPC cannot be invoked in non-criminal proceedings such as those under the Customs Act. This was so held by the Kerala High Court in the case of P.O. Thomas versus Union of India, 1990 CRLJ 1028. Further, my dear students, in the case of State of Haryana versus Bhajan Lal, 1992 SCC Criminal 426, wherein the Supreme Court has laid down various guidelines for the exercise of its jurisdiction under section 482 CRPC. Some of these illustrations or guidelines are as under: where the allegations in the FIR, even if they are at their face value, do not prima facie constitute any offense against the accused. So these are some of the examples in this regard. Further, in the case of R.P. Kapoor versus State of Punjab, the Supreme Court has held that the inherent jurisdiction of the High Court can be exercised to quash proceedings in a proper case, either to prevent abuse of the process of any court or otherwise to secure the ends of justice. Ordinarily, criminal proceedings instituted against an accused must be tried under the provisions of the code, and the High Court would be reluctant to interfere with the said proceedings at an interlocutory stage. Further, my dear students, the Supreme Court, in the case of Mary Angel versus State of Tamil Nadu, 1999, 5 SCC 209, wherein the Supreme Court has clarified that Section 482 could be invoked to award cost. In the result, we hold that while in exercising inherent jurisdiction under Section 482, the court has the power to pass such orders, including the order for cost, to give effect to any such order passed under the code, or to prevent abuse of the process of any code, or otherwise to secure the ends of justice. As stated above, this extraordinary power is to be used in extraordinary circumstances and in a judicious manner. Cost may be made to meet the litigation expenses or can be exemplary to achieve the aforesaid purpose. So with this background, I just want to start with the today's topic, that is drafting of an application under section 482 CRPC. So my dear students, as you are aware that the inherent power can only be exercised by the High Court in case of the proceeding initiated under the Code of Criminal Procedure. As such, the application regarding or under section 482 CRPC must be filed only before the Honorable High Court of the state. As such, the format contains the application is made before the Honorable High Court of Delhi. As such, you have to mention like this in the High Court of Delhi at New Delhi. Thereafter, you have to put that it's a criminal miscellaneous application number so and so, and in thereafter you may put in FIR number or criminal complaint number as the case may be. You may put it afterwards also like this. Thereafter, you will mention about the parties involved or the applicant involved in this case, meaning thereby to explain the nomenclature of the parties herein. A, son of Siri so and so, residence of so and so, is the applicant. As you all are aware that the criminal proceedings is initiated by the state government. As such, the state needs to be made the party. As such, before the Honorable High Court of Delhi, you may make the state of NCT of Delhi as one of the party. Thereafter, you will make Srimati Sheila Devi, wife of Mr. A. In this case, the case is that of a case and filed by the woman under section 498A IPC against her husband. Here, Mr. A is filing this application before the Honorable Court. As such, both state government as well as the wife of Mr. A has been made the respondent in the case. Thereafter, you have to explain about the application title as well. And you may put the application title like this: application under section 482 Code of Criminal Procedure for quashing of FIR number so and so registered at police station so and so under section 498A IPC. Thereafter, you will explain the facts of the case. And one of the case point which needs to be mentioned over here is that in the facts that the marriage of the applicant was solemnized with the respondent number 2 as per Hindu rites and ceremonies on 21st February 2011 at Delhi, whereby this particular clause indirectly refers to the arose of the cause of action in favor of the woman which had filed the case before this honorable trial court, and thereafter which also gives the cause of action for the husband to approach the High Court for quashing of that FIR under section 482 CRPC. Secondly, that due to some misunderstanding, the respondent number 2 filed an FIR number so and so under section 498 IPC against the applicant. So this is the second fact. Third, that the applicant was released on bail via bail application number so and so on itna. You have to mention the date also over here. Thereafter, The applicant and the respondent number 2 had sought divorce by mutual consent under section 13B of the Hindu Marriage Act from the court of Saket Additional District Judge. The applicant agreed to maintain the respondent number 2 by giving her rupees so and so per month maintenance and all her claims in respect of dowry, articles and streethan. A certified copy of the petition number so and the affidavit and the statements of the parties recorded for divorce on the ground of mutual consent as enclosed herein as annexure number so and so. So as the parties have taken the divorce by way of mutual consent and respondent number 2 or the applicant herein has agreed to give her maintenance. Thereafter, the wife had agreed to withdraw the criminal complaint filed or criminal case filed by her against her husband, and thereby he sought the quashing of that case under section 482 crpc. Thereafter, you will mention that the respondent number 2, as per the mutual consent, had also undertaken to assist the applicant in getting the FIR quashed from this honorable court. Now, at the last, you may mention that as the parties have compromised all their dispute, it is in the interest of justice that FIR number so and so, registered at police station number police station so and so, is ordered to be quashed. So thereby, you may make a request to the honorable court that as the compromise have been entered into between the parties, as such, there is no need for further criminal proceedings in the said case. Thereafter, you will make the prayer before the honorable court, wherein you prayed before this honorable court as it is therefore prayed as that the FIR number so and so, registered at police station so and so, under section 498A IPC may be quashed, and any other order which this honorable court may deem fit and proper under circumstances of the case may be passed in favor of the applicant and against the defendant or the accused, as the case may be, or against the respondent. So this is all about today's lecture. But before parting with today's lecture, I just want to put before you my new topic, which I am going to take in my next lecture. And the new topic which I am going to take in my next lecture would be on convincing. Thank you very much. Stay home, stay safe, and stay healthy. We'll meet you soon in my next lecture. Thank you once again.